very warm good evening to everyone present. Uh, Today we have for webinar Mr. Dr. Ashok R. Patil, Professor of Law and Chair of Consumer Law and Practice, Ministry of Consumer Affairs, Government of India, Coordinator Internal Quality Assurance Cell, IF and NIRF. We welcome Mr. Ashok for today's session, the webinar session. Uh, Ashok sir, over to you.
Yeah, thank you.
Yeah. Ashok sir, if you would like to tell us something about the area field of specialization that you're working on, mediation, a brief
Yeah,
about it, it would
yeah,
help.
sure.
Thank you.
Okay, can you see my PPT?
Yes,
Yeah, clearly.
it's visible, yeah.
Thank you very much for giving me this opportunity to share my experience in mediation field. And at the outset, my sincere thanks to young and energetic man behind this webinar, Navi sir. So I'm uh, associating with him since maybe 2005. When I was in Belgium, KLE Law College as a principal, we started then diploma in cyber law in Law College in Belgium. So later I joined National Law School, and here also we continued that relationship. Very dedicated, focused, uh, hardworking, simple person. So and also we were working together in when we established a online consumer mediation center at National Law School, which was the pilot project of Minister of Consumer Affairs, Government of India in 2015-16. We discussed a lot of things in bringing out the online mediation center as a pilot project. So that is the background, my relationship with now Vijay Shankar. So when he asked me without any uh, thinking, I said yes for his dedicated work. So I'm before you now. So here a lot of experts are there, advocates are there, IT people are there, many people are here. Just I'm sharing my experience, and even my idea is to get some inputs from your side also, so that we can grow together. So that is the object behind it. Especially on mediation, I involved, started working on it in 2010, 11, like that, when Minister of Consumer Affairs started thinking of mediation under the Consumer Protection Act. And we worked last 9 years, because I'm heading a consumer chair, which is established by Minister of Consumer Affairs, Government of India. Since I started in 2008, since then I'm heading that. And object of this, the endowment chair of Government of India, is to help Minister of Consumer Affairs in policy matters, amendments, new legislations, framing rules, regulations, all these things together, and even training the consumer forum judges and publications at the international level and national level. So these are the objects behind establishing consumer chair. And when we thought of coming out with a mediation uh, chapter in the new legislation, we started thinking of amending the 1986 Act, Consumer Protection Act 1986. And then we started adding one independent chapter on mediation. So ultimately, that legislation came into force in the name Consumer Protection Act 2019. And later this year, 24th July 2020, it came into force in India, throughout India. So that is the nature of work I did behind this new legislation. And also, we worked with the Ministry of Law and Justice on mediation. So 2018, we discussed 2-3 meetings we did with the Ministry of Law and Justice, and they got our inputs, and they recognized the institutions who are working online, and they notified on their website, and they sent to all states. These are the mediation centers. You can take or avail of these facilities. And in 2016, the Minister of Consumer Affairs requested us to start online consumer mediation center. That's a pilot project, exclusively between disputes between e-consumer against e-commerce companies. So we were having a lot of challenges, and because it was a pilot project, we submitted all the information to the Ministry of Consumer Affairs. Then that was shared with the Ministry of Law also. And now some of the inputs have come out. Recent new draft designing the future of dispute resolution, the ODR policy plan for India, October 2020. So that is now before us to give, and I request you all go through that particular document and give your feedback also, so that effective, practically possible, the policy can come out from the Government of India. Let us come back. So we have seen this statement in all the manufacturing sector or service sector. The gist of this statement is consumer is a king, but practically it is not happening everywhere. That's why the Ministry of, under the Constitution, the articles are provided right to do business, but it's not an absolute fundamental right. That's why the Article 19, Clause 6 puts a restrictions on trade or business, so that in the interest of public, to protect the consumers or customers. So that's why a lot of welfare legislations have come. Coming to the topic, we have seen already what type of problems we are facing in regular courts. Why ADR concept started? Why not all disputes settled in the regular courts? So in regular courts, you have seen, just I will go to that particular slide. So in litigation, nothing is under your control once you go to the regular court. Once the case is filed, suit is filed, you have to hire advocate. You cannot do your case in person because it's a complicated procedure. Civil Procedure Code, Evidence Act, many other legislations as a protocol applicable in civil code. So that's why layman cannot appear in person and argue his matter before the regular court. And once you assume that once you file a case with the help of advocate, then it is not it is not possible within 3 months or 5 months or 1 year it can be settled, unless if they are not, or if they are following ADR methods. Regular court, it takes its own time, and maybe many reasons. Maybe advocates are taking adjournment, or a judge is transferred every 3 years. A judge is transferring in trial court, and parties are not serious. So one or the other reason, cases are going on. Recent, you have heard the Justice, the Supreme Court Judge, Justice, one of the judges of Supreme Court clearly said now there is a need for ADR, and Also, he has given a lot of statistics. Unless we follow EDR, it is very difficult to dispose of all the cases. So that is the situation. And here, the adjudication procedure is very complicated in regular court, and parties not in control, they cannot appoint their judge in regular court. If I want to, this particular Mr. X judge is a good person, so I want to appoint him as a judge in my case. That liberty, freedom is not with any of the parties. So you have to file a case. It will go as per their internal adjustment arrangement. So in that way, it works. Otherwise, the parties don't have a control on that. Then no time limit for decision making. So depending on the situation or nature of case, it will take maybe 5 years, 10 years, some cases 15 years. There's no end for it. Even though a lot of Supreme Court judgments are there, you have to dispose of at the earliest, but one or the other reasons, the civil cases are not disposed of quickly. Then multiple appeal, even though you got a judgment in your favor in trial court, then appeals, High Court, Supreme Court, many appeals are there. Again, that appeal takes a longer period. So throughout the life, at the age of assume that 20 years, if he entered in the dispute resolution or case, his life will go in this case itself. And maybe you experienced one who has filed a case, how his mind is working, how his health is working, or the environment around surrounding him, the family members, everybody is in tension because of this case, what will happen, all those things. So these are the side effects of civil court case continuously going on for a longer period. Then cost and time. See, you have to pay court fee, heavy court fee. It's not a negligible court fee, small court fee. And along with that, time, you have to spend a lot of valuable time. If that time is used for any fruitful work, you could have enjoyed that particular time and revenue or any other things you could have got. But unnecessarily, here we are wasting time in civil court because of these reasons. Then the win-lose approach. So in civil court, it's a very rare both plaintiff and defendant won the case. Both won the case. No, not possible. So here, if the judge is giving a judgment, then one is losing and one is winning the case. And throughout their life, they will be enemies in their life. So there is no cordial relationship between those two people. So, and once the case is in court, judgment is given. So every day during the case, examination chief, cross-examination, argument, so whole public will enter the court, the parties in the witness box, everybody observes your day-to-day case, what is happening. And also once a judgment is given, that judgment is open to the public. It will be published and everybody can read what has happened to this person or this company. So whatever matter, so it will be in public. And next question comes reputation. Once the case is decided, all the documents are in public, and the reputation in future because of this case may come down. So all these problems are there. So why we should file a case in a civil court? Is there any alternative way? And now looking into the cases, every day population is increasing, every day cases are increasing, proportionately courts are not increasing, proportionately judges are not increasing, and that proportionate increase also impossible. That proportionate, that speed in future is impossible. That's why the legislature thought of amending civil procedure code section 89. They have introduced this ADR, alternative dispute resolution. So alternative dispute resolution, it has the arbitration, conciliation, mediation, judicial settlement, lok adalat. These are the uh, methods they have prescribed. So now we are concentrating on mediation only. About the mediation, it's a voluntary process. The mediator facilitating the disputing parties and trying to settle the matter amicably with their consent. So once the decision is given as a mediator, so it's not called as a decision, settlement is done, both parties are signing and mediator is also signing. So that is a mediation, both parties are happy at the end. So there is no win-lose situation, it's a win-win situation. So this is the mediation we are concentrating here. And this particular mediation process is not governed as on today by independent legislation. Arbitration and conciliation is governed by Arbitration and Conciliation Act. Lok Adalat is governed by Legal Service Authorities Act. But mediation, there is no exclusive legislation which governs what is mediation, who are the mediators, what is the qualification of the mediator, all these things. I'm talking about independent legislation like Arbitration and Conciliation Act. There is no legislation. But first time these mediation is recognized in Commercial Courts Act through amendment in 2018, pre-litigation through mediation, pre-litigation settlement through mediation, section 12A added in Commercial Courts Act, and rules are also framed. And actually, this concept of mediation adding chapter was introduced in the 2000 Consumer Protection Bill. Actually, it was first time one independent chapter introduced in the Consumer Protection Bill 2015, but it took 4 years to come into force in 2019. Meanwhile, this particular Commercial Courts Act, they introduced one particular section, section 12A, commercial courts cases can be referred to the mediation. So that is section 12A. After that, the Consumer Protection Act 2019 came into force, and 24th July 2020, it is enforced or came into force throughout India, notified. So now independent chapter is added in this Consumer Protection Act. Now, I said no independent legislation, yes, but one big chapter is added in the Consumer Protection Act, and one or two provisions made in the other legislation, and one important legislation is the Commercial Courts Act. So who can be appointed, which cases can be referred, so all those things are as per that legislation. If consumer case comes, the Consumer Protection Act mediation chapter applied, and rules and regulations under the act are applying. If it is a Commercial Courts Act, then as per the section 12A and rules framed under Commercial Courts Act, that is applicable. So now this is the way it is working. And mediation is two types, we can say pre-litigation and post-litigation. Pre-litigation, before going to the court, if both parties understood that what are the pros and cons of going to the court, they can decide. So without going to the court, we can request one mediator from mediation center. Now, lot of private mediation centers are established throughout India. Even one is with a national law school which I'm heading. So they can make use of the existing facilities, and they can settle the matter. Question comes sometimes, if both parties are agreed amicably without any force and settlement is done, then both parties are happy, win-win situation. There is no question of going to not following the decision or not following the settlement terms and conditions. So that is pre-litigation. Post-litigation is case is filed in the court or quasi-judicial authority or tribunal. Those cases can be referred to mediation. So that's a post-litigation. So post-litigation case is referred to the mediator. Mediator amicably decides and submits to the court from where it is referred. Judge puts his seal and signature, that becomes a decree. So that is another way. So this is just a glance I'm giving. Coming back to the aspect. So usually when dispute comes, there is a confusing or understanding the parties each other. So disputing parties, sometimes they block their mind. They are not thinking openly. If they think openly, then disputes will be less or nil. But if they are not thinking broadly, then there will be a dispute and the problem starts. So we have to stand in both the parties' position and think why he is or she is thinking in that way. If we think and act, then there will be a lot of problems can be solved. So here, as per this person, he says 4. Yes, 1, 2, 3, 4. And as per this person, it is a 3. 1, 2, 3. In their place, they are correct, but they are not understanding each other place. So that's why dispute starts. So as a mediator, I have to understand in both the parties, disputing parties' position. Now, I assume that I'm a mediator. I will stand in this person's position, think why he is saying like that. What are the reasons behind? What are the causes? So same way, I will stand in his place and I will see in his angle. So I can understand both the parties' understanding and reasoning why this dispute started. Then as a mediator, it is very easy for me to facilitate these people to settle the matter. So like this, we can take other examples. So which side he is seeing, front or side? So same, the disputing parties, one says the side he is saying, another says front saying. So that is the way how dispute starts. So this is one person says 6, another person says 9. In their place, they are correct, but they are not understanding each other's situation or position. So they are completely under confusion. They are not able to come out. So that's why they go for the case, files a case, and they start get confusion. Yes, there are some part they may not settle what they want, both the parties, but always there is a space for compromise. compromise. Some extent they may not compromise, some extent they may compromise, keeping longer vision. So in future, if it is a business, in future, if they work together, both will get a benefit and relationship will be good. Reputation in the society will be good. Reputation in the market, it will be good. Mind is cool. So all these benefits are there when the case is settled through mediation in win-win situation. So that's why the mediation is the best method. And especially why mediation? Is it anybody can act as a mediator? So one of the Supreme Court work manual on mediation, they clearly, one of the committee submitted a report, they clearly mentioned 40 hours training program is for the to become a mediator. So that is done by recognized institutions. Last year we did 40 hours training program. Now if you want to become a mediator in civil court, especially they appoint advocate as a mediator. So even anybody cannot become any advocate cannot become a mediator. So he has to undergo 40 hours training from the High Court annexed mediation. So they have a training program. So he has to, that is also, there are conditions for the 10 years he has to practice in court, and afterwards he should apply, and 40 hours training he has to undergo. Then he can be designated as a the mediator, and every court has a mediator's empanelment. So on that basis, depending on the nature of case, the case is allotted to that particular mediator. So that is the thing. But there is no law which says only advocates can become a mediator. So it is an arrangement at the High Court level or Supreme Court level. So we do many private mediation centers gives training for any degree holder. Any degree holder. We also trained for any degree holder. So this mediation skill, unless the law specifies only advocate mediator should be come on panel, then only prohibition for others. If it is a silent, then one who is not an advocate, who is having a mediation skills, he can also act as a mediator. It's a psychology, or it's a understanding of the human mind of disputing parties and try to settle the matter. In foreign countries, last year I went to Perth, Australia, and many other countries. So there, the psychology professor teaches the mediation, and some places psychology professor as well as law professor together. So it is nothing but the assessing the mindset of both the disputing parties. So once you understood the nature of the parties, then it is easy for the consumer to settle the matter. So this is section 89 of Civil Procedure Code: arbitration, conciliation, judicial settlement through Lok Adalat and mediation. So arbitration and conciliation governed by Arbitration and Conciliation Act. Judicial settlement, Lok Adalat, Lok Adalat is governed by Legal Service Authority Act. Mediation is no separate legislation, but presently governed under the independent legislation, rules, regulations. As I have mentioned, the Commercial Courts Act, 1 Section 12A, and under Consumer Protection Act 2019, 1 independent chapter, rules and regulations are framed under that. So here I may not go in depth, just I can take a difference why mediation is important than arbitration or conciliation. So arbitration, again, one person as an arbitrator is appointed, and there you cannot, if you are not interested, you cannot come out from the arbitration unless valid reasons. So here the arbitrator somehow he act like a judge, not in the clear sense as a judge, but hears the both the parties, and on that basis he decides, even though one party is not ready for the settlement or his decision, the judge or the arbitrator is not ready to listen, he gives his decision on merit. But here in mediation, yes, you entered for the mediation procedure, but at any stage, if both parties are feeling not happy, then you can stop there, you can come out from the mediation. You are free at any stage, you can come out from the mediation proceedings. Nobody can stop you, and everything is informed. So the nobody can force in mediation. So that's why no force, everything is educated, and according to their terms and conditions are put in the agreement, and finally both parties are signing and mediator is signing. So here benefit is both parties are happily with consent, they put their terms and signing that. It means they are not going for the uh, dispute, or they are not taking ahead that dispute. So both are happy, both will go with a good relationship in future throughout their life. So that is the mediation. But in arbitration, there also one person will win, another person may lose. And coming to conciliation, so conciliation here, the conciliator in the Indian scenario, conciliation, conciliator, he actively involved in decision making. So he suggests, advise. So all those things happens in the conciliation, which is not happening in the mediation. Mediator is not advising anybody. He is not giving his opinion. So he is just a facilitating. See, that is the nature of mediation. And ethics is there. As a mediator, he should have a ethics, code of conduct for the mediator. So he should not share whatever he is discussing with the parties. So in the mediation, there will be a caucus session, separate sessions with the both the parties. There will be a joint session. So depending on the type of case, depending on type of dispute, the type of the people, disputing parties, the mediator has to decide what he has to, take a decision. Is it a caucus session or joint session? So again, if there is no concrete rule, each case is different, parties are different, their mindset is different, same procedure or set of rules may not applicable to another case. So as a mediator, keeping his ethics, code of conduct, he can decide what he has to do. Ultimately, the object is for the amicable settlement. So that is the thing. Judicial settlement, yes, court settlement, and through Lok Adalat. So case can be referred to Lok Adalat. Lok Adalat is established under Legal Service Authorities Act, and it goes to the Lok Adalat, and Lok Adalat will decide, comes back to the court, and again court puts its seal, that becomes a decree. So this is way how it works. That's why out of these four, the mediation is completely under the control of the disputing parties. So that's why it is very important. Now it has got very importance because of recently in 2019 Singapore Convention on Mediation. India is also signatory. So cross-border disputes can be settled through mediation, that is Singapore Convention on Mediation. So that is very important. boost for mediation, the sector mediation area, and mediators will be flourishing in future, especially in cross-border disputes as well as internal the dispute. So that is a very, very important development. And also the recently UN guidelines on consumer protection, UN guidelines on consumer protection 1985, that has amended in 2016. They have added ADR. So now ADR is introduced in all the countries, and they are thinking of that is a suitable one. This is a case landmark judgment, Afghan infrastructure versus the Cherian case 2020 Supreme Court. Justice Ravindran has given very good judgment. In detail, he has discussed how mediation works, how ADR works in India. So you should go through this particular judgment, which cases can be referred to mediation, which cases cannot be referred to mediation. Everything is discussed in this judgment. I'm taking some very important points, paragraphs. So this is the thing, which cases cannot be referred, excluded for this particular mediation. So that is the public interest or interest of numerous persons. So that is those types of cases are excluded from reference. Then election to public offices, election cases are cannot be referred. Then grant of authority like a suit or suits or grant of probate or letter of administration, so that is not allowed. Then serious and specific allegations of fraud, fabrication of documents, forgery, impersonation, coercion, these types of cases cannot be referred. Then protection cases like protection of minors, deities, mentally challenged, these cases cannot be referred, and criminal offenses. So these are the types of cases which cannot be referred to ADR, alternative dispute resolution. Anything, you may take arbitration, mediation, conciliation, anything, these cases, these types of cases cannot be referred. Then what type of cases can be referred? So all cases relating to trade, commerce, and contracts, all cases arising from strained relationships such as matrimonial cases, all cases where there is a need for continuation of the pre-existing relationship, such as disputes between neighbors and members of society, and all cases relating to tortious liability, including motor vehicle accident cases, and all consumer disputes. So here, this is also one of the reasons why the Consumer Protection Act introduced new chapter. So this case is also one of the reasons behind it. So looking into the Consumer Protection Act, I will look into these two legislation, how the mediation chapter is added. So especially Consumer Protection Act, new act introduced three new chapters. One is Central Regulatory Authority is introduced. Second one, Mediation chapter is introduced. Third one, Product Liability chapter is introduced. Now it is very strong legislation in India. So in future, it is very difficult for the manufacturers or service providers doing wrong things and escaping from the Consumer Protection Act is very, very difficult because of the Central Regulatory Authority. They are already, it is established at New Delhi. Srimati Nidhi Khare is a chief commissioner of this authority. And they have a suo motu powers, investigation powers, recall powers, and search and seizure powers. Lot of powers are with the regulatory authority. And the product liability, product recall, manufacturer's liability, seller's liability, lot of other things are included. Even this new legislation major part throughout the legislation. If you look into that, e-commerce is completely covered. E-commerce platforms liability, sellers on e-commerce platforms liability, exceptions, that is also discussed, and other new areas like the advertisement is defined, misleading advertisement is defined, and also the endorsers liability is also discussed in this. So now under 1986 Act, we were saying that it is a civil legislation, but now under the 2019, imprisonment powers are given. Imprisonment powers are given to commission. We may not say now it's only civil law. It is a mixture of civil compensation as well as imprisonment together. They will order. So this is the thing, and this is a chapter 5, mediation chapter. So here, this is the way, section 74 to 81, and all these sections, ultimately what it says, that section 74, under the Consumer Protection Act, there is a 3-tier redressal system: district commission, state commission, and national commission. So pecuniary jurisdiction as well as territorial jurisdiction is defined. As per that, the cases are filed before the district commission or state commission. Assume that it is filed before, they want to file it before the district commission in Bangalore. So before taking or hearing the case, the Consumer Commission will refer this case to the mediation cell. Mediation cell or mediation center are attached with the district commission, every district commission, every state commission, every national commission. So always there should be a mediation center. And if the judge, the commission members think that it can be settled through mediation, then they can refer the matter. And they will select the mediators. So mediators has to apply with all the details, and looking into the qualification, experience, they make a list, and depending on the nature of case, they refer that mediator to nominate that person to the that particular case. And duty of the mediator, he should not have a personal interest in the parties. He should not have a relationship, any personal relationship. So all those things, he should be a neutral. Mediator is nothing but is a neutral party. He's not biased towards any of the parties. He should be neutral. Then only he's a mediator. If he wants to survive as a mediator in the society or in his profession, that ethics is very important. If he misguide or misuses that particular profession, from next time, it will be publicized everywhere, and no party wants to select that person as a mediator because he is not following the ethics of the mediator. Then during the mediation procedure, if any of the parties feels that he is a biased person and he is not listening to you, then the parties, disputing parties, can give a application to the Consumer Commission, and Consumer Commission will replace that mediator also. So on the complaint, they replace the mediator. Then procedure should be followed. The procedure is, before starting the mediation, the mediator should say that I'm not a judge. I'm here to facilitate both of you. I want to listen to your the dispute facts, and you are always welcome in between. You can say, I don't want to share this particular information before other party. Then we will go for the caucus session. There you share your information, and there also how much shared information can be shared to the opposite party. That also the party can tell the mediator, I told you 10 points. Out of 10 points, don't share first 5 points with the opposite party. So as a mediator, he should have a confidence. He should maintain that confidence. He should not share with the other party. So that is the ethics part of the mediation. Once the settlement happens on their terms. So whatever they use the words, the same words can be put on the paper and both parties will sign after reading that. Even here, the both parties can bring their advocates also. There is no bar. If they feel that it's a high stake, then they want to advocate, they can bring advocates. So amicably, they should settle the matter. And sometimes assume that mediation is referred, 5 issues are there. All 5 issues may not be settled. On 3 point, case is settled, they are agreed. Another 2 point, they are not ready to settle. So now, out of 5, 3 are settled. On those 3 points, the settlement can be done. The rest of the 2 points, you leave it as unsettled. Same report you submit to the court or the mediation from which court it has come. So that court will take it for 3 issues. The case is closed. The rest of the 2 issues, that case will continue in that court. So same way here also, section 80 and 81, here also it is doing the same thing. So this is about the mediation chapter in the Consumer Protection Act. Now I go directly to the Commercial Courts Act. This is the Commercial Courts, Commercial Division and Commercial Appellate Division of High Courts Act 2018. Actually in short form, it called Commercial Courts Act 2018. So new section is added, section 12A, pre-litigation, mediation and settlement. So section 12A, a suit which does not contemplate any urgency, any urgent interim relief under this act shall not be instituted unless the plaintiff exhausts the remedy of pre-institutional mediation. It means case is filed before the commercial court and there is no urgency to get the interim order, then the commercial court should check that have they gone through pre-litigation mediation. If they have not gone, then the commercial court should refer to pre-institutional mediation. So here, the court is making mandatory that first you exhaust that particular pre-litigation institutional mediation, even though they may say mandatory, go through that mediation procedure. They may say go through that mediation, but no court can say you settle through mediation. Nobody can say, otherwise the meaning of mediation itself will frustrate. So mediation, whichever court it is, mediation is a mutual settlement amicably. That is mediation. If one party is not ready, then mediation settlement cannot happen. So any stage they can come out and say, I'm not interested to settle the matter through mediation. Let it go through the normal procedure in civil court. Then that power is given to the legal services authorities, which are established under Legal Service Authority 1987. You have seen under this act, 3 authorities, District Legal Service Authority, State Legal Service Authority, and National Legal Service Authorities are established. And those authorities have to look into frame rules for the mediation under this particular legislation. So they have framed rules also. And complete the process of mediation within 3 months from the date of application made by the plaintiff. If both parties are agreed, then they can extend more. And pre-institutional mediation, such a period shall not be computed. So if a case is referred to mediation, it is not settled, again came back to the court. Whatever period is spent in the mediation proceedings cannot be counted for limitation. So limitation, your case is barred because of a limitation. You have crossed that limitation period. So they cannot say, and that period which is spent for the mediation, that cannot be counted. That cannot be, counted in the total number of years. So that is provision is given. And once they arrive at the settlement, same shall be reduced in writing. Both parties have to sign and submit to the court. Settlement arrived under this section shall have the same status and effect as if it is arbitral award under Arbitration and Conciliation Act. The rules are also framed by the central government. These rules are framed by the central authority, central legal service authority, national legal service authority. If your claim is 3 lakh to 10 lakh, 15,000 is a mediation fees, and 30,000. So this is a mediation fees as a mediator. Now it is a profession. Mediation is a profession. One part of a profession, any profession you can do, but this is also now recognized as an independent profession. And now recently this year, Bar Council of India sent a letter to all law colleges to start one independent mandatory subject on mediation. So now every law college has to start independent subject on mediation. So this is mediation fees. And once the case is settled through mediation, then whatever court fee you have paid, that will be refunded. That is the benefit of the settlement through mediation. Now coming to the online dispute resolution, ODR, online mediation, online arbitration. Now things are shifting, especially this COVID era. Everybody got or come to know the importance of online. So even Supreme Court, High Court, everywhere the online hearing is happening, and online dispute resolution, alternative dispute resolution that is also happening. Now online dispute resolution, ODR. Now we can say online mediation. Let us concentration on online mediation. One of the Supreme Court case constitutional bench decided. Supreme Court said access to justice is a fundamental right and laid down 4 main facets of the essence of access to justice. What are those 4 pillars? State must provide an effective adjudicatory mechanism. The mechanism so provided must be reasonably accessible in terms of distance. The process of adjudication must be speedy. The litigant's access to the adjudicatory process must be affordable. So all these 4 essential elements are available when we shift to online. So online mediation. So anything you take online is more comfortable. Again, there are some challenges. 100% every litigant cannot afford this one because of his background. But majority of the cases, majority of the people may shift because nowadays nobody is having a time to going to the court and settling the matter. So now they can choose for online mediation, sitting in their house, sitting in their home, they can do that. So this is the online consumer mediation center we started as a pilot project 15 to 18. Only for 3 years we did it, and we have given our report to the ministry, and those objects, those points are covered under the new ODR policy plan. So if it is a online mediation, these are the instruments. and it is very easy for everybody sitting in home, on bed or office. They can participate in the mediation program, and you can send your receipts, bills, photos through online. Whatever is happening in court or physical ADR methods can be done online. Nothing is stopping that. Only our mindset has to be changed. Yes, we can do it online. And new mediation toolkit, video, phone, email, face-to-face, lot of things are there. We can make use for the settlement. So these are the very important online mediation. Recently, 2 years back, I visited Beijing, China. They have established an internet court. Everything is online, and latest technology they have used, and around throughout the world, around 10 15 people we were there for discussing on online mediation. And this is uh, established or designed, all software, everything is assisted by Alibaba. So they have helped this internet code. So this is a mediation sent mediation room. This is a mediation room. When we say that it's online, why there is a mediation room? The same thing is applicable to India also. Everybody may not have access of these facilities. So in those for those people, facilities are existed in the consumer forum or regular court, like how it is there in the internet code. So we can make use of these facilities, internet or all the infrastructure, e-infrastructure can be used. So when we say that it's a mediation private session is happening, and they have put a transparent glass here. So what they have done, it's a transparent when nothing is happening. Once the mediation starts, there is a button. If they switch on that, this glass becomes non-transparent. So whatever is happening inside, nobody can see, nobody can hear. So that type of room. So I have made a video. Let us uh,
So this is a mediation room. 在里面坐的是调解员，yeah, the mediator is sitting in there, and this one is also have you seen? So sound protection is also. 他说这个是隔音的，隔音的，yeah, also sound is called 隔音的. So they can have the total privacy to perform the mediation. 这个可以放在地铁可以上啊，地铁上啊，都可以。The mediator, this is just for a demonstration, or this is real one, but they don't have to be here. They can be at home. Now they can be on the train. They can just hold their cell phone to do the mediation. 那个被告是在哪里？被告在上面。The disputed parties are in the.
So like this, many mediation rooms are there. So the one who is not having a infrastructure in their home, they can come and make use of this. And how it works, the entry will be on the first time entry. That can be done by registration phase. The doors will open by just you show your eyes, that will open, and your records, they will enter just like a WhatsApp. They are having a separate type of WhatsApp. So there, from that, all the data will be transferred to the computer. Then they keep that particular record permanently. Whenever a person comes, enters, so automatically, if it is that person is registered, automatically door will open. So all the procedure, everything is there. And also, that's a thing. And there is a robo also. If your layman goes and asks questions, that robo takes to the concerned person and helps that particular person. 2, 3 robos are also there. And this is one government of Department of Justice, Government of India, online dispute resolution through mediation. So 2 meetings I have attended personally with the secretary, and the 2 meetings I attended with National Legal Service Authority chairman, then Justice Lokur, who worked on especially on Commercial Courts Act rules and regulations. They requested the help of existed centers. So a lot of challenges are also there. Still, people are not aware of mediation, how it works. They think that this is also court. Once you go to mediation, it should be settled by the judge. So like that, people are thinking. And also more support is needed from bar and bench, and even advocate profession. Advocates should increase that, so that it will be helpful for the parties, and they can reduce the burden on the regular court. And ODR project from Law and Justice, as I've said, we have involved and encourage cross-border dispute. Now this particular Singapore Mediation Convention has passed. So now we are concentrating on artificial intelligence. So 2 meetings we did with Ministry of Law and 1 meeting with the National Legal Service Authority. And recent one, the Justice Sikri is one of the best judge. Always he encouraged ADR. And in his last judgment before retiring, this is a Krishnamurti case, he clearly mentioned that Supreme Court exams experts committee, here they said that feasibility of enacting Indian Mediation Act to take care of various aspects of mediation in general. He clearly mentioned there is a need for independent legislation on Indian Mediation Act. On that basis, Supreme Court appointed an expert committee also to frame bill. So it is now on the process, it is working. So in mediation, trust is the only one character. If trust is there, trust between the mediator and parties. So if there is no trust, then mediation is not successful. And now you can access in Google, designing the future dispute resolution, the ODR policy plan for India. So that is available online. You can go through that. With this, I conclude. Thank you very much. A lot of things is there, but because of the shortage of time, we cannot take much time. So here I'm concluding. Thank you very much.
Thank you, Ashok. Any questions from participants?
I posted in chat box, sir.
Yeah.
Question from Mr. Limai. How much cases in consumer forum you foresee can be settled at mediation stage? What is the timeline to set up mediation centers for district consumer commission? Ashok?
Yeah. So here, especially this particular Consumer Protection Act came into force 24th July 2020. And even state governments have not yet established, just it is July, August, September, now we are in October. So implementation, especially in India, making laws, enacting laws is easier than implementation. So every state has to implement, give infrastructure for mediation. So presently, mediation cells are not established. So you cannot get any statistics. Maybe 1 or 2 types of cases can be settled, but not a big number of cases settled through mediation as on now. And About the timeline, yes, 3 months are given to settle the matter. If it is not settled, automatically comes back. If both parties thinks that it can be settled by extending another 15 days or 1 month, then mediator, with the consent of the both the parties, can request the court give extension for another 15 days or 1 month. So like that. So always mediator should always cautious, neutral. It should not be misused. Mediation should not be misused for dragging of the case. So that he should keep it in mind. Thank you.
Thank you.
Any more questions?
So I had a question.
Yes, Anupam, go ahead.
Yeah, sir, I really, I'm a corporate lawyer by profession, and I had a question. Of course, mediation has been around for a while under Section 89 of the CPC, as you had pointed out. And you had also emphasized on the fact that there's a strong element of trust that the mediator should obviously have. So when we are talking about two adversarial parties who are unhappy in a case situation, and therefore perhaps they may adopt mediation, but the element of trust is anyway lacking, therefore they are against each other. So in this context, how does mediation fit in? I understand one may go into mediation considering the status of the pendency vis-a-vis the courts across various levels of courts that are there. So my question is, to cut a long story short, in terms of the trust factor, how does mediation fit in? Because if I have an issue, do you think it might defeat the purpose of it all, and thus not see the success that we hope to see vis-a-vis mediation?
So you're asking about trust between whom?
No, between the parties. I would assume if there's a problem and people are looking at a dispute resolution.
Okay.
In a very practical, yeah, sorry, go on, sir.
Yeah. So here, that's the thing. The parties as on today not well versed with the what is mediation. Even they are not thinking of there is a mediation, and they are going for the court. It's a very less number of people who knows it and using it. And another thing about the trust will not come overnight. It has to grow time to, by period. And everybody should involve to increase the trust. Bar and bench, the government, parties, awareness program, all together, if we bring the awareness to the society, then they may slowly trusting the mediation process. Here, assume that yes, he trusted and he entered. Later at any stage, if he or she found that there is a trust lacking in the mediator itself, there are a lot of other the alternatives are there. They can inform to the court or the other party, and they can change, or he himself can be come out from the mediation. And also why we should think that only court is the alternative way. Court is the only way, there is no other way. So here if there are two the companies are fighting, and both are in past they have a good relationship, they are depending on each other. On one small issue, now there is a dispute. If they decide it in court, then both parties who were the friends, in future there will be enemies, and in future they will not cooperate each other. So we have to think not at present, in future, throughout my life, throughout my future business, is it helpful for me or not? So to that extent, we should broadly think, some extent compromise, some extent future relationship, future orders. On that basis, we should go ahead. So that is my personal opinion, sir.
Sure, sir. Thank you. I guess we need to start somewhere. So it's a good start, hopefully. Thank you.
Yeah, any other questions? So basically, since mediation is a mutually agreed system, uh, they need to have trust in the system. Okay, first, then perhaps they can try it out. And since it is not mandatory to be bound by the decision, they can give it a try. Where distrust comes is, if you go in for mediation and during mediation you share certain confidential information, hoping that say the other party will come down and compromise or something like that, and later on the mediation fails, then the question is whether the information which you have shared can be used against you in the follow-up litigation. Normally in the mediation, we have a confidentiality agreement which will say that whatever is discussed within the mediation is not to be used extra in any other litigation process outside. But still, we never know that any confidential information shared may be intelligently used against the particular person. So to that extent, what you say is correct. Trust is required. But hopefully, if people know what is mediation, how to handle it, and the mediator and the counsels who may be helping these people are able to guide the parties, then perhaps they can ensure that they try to list down what are the areas where they can agree together and work only around that, and they will be perhaps mature enough to avoid giving away any of their trade secrets which may be used against them later on. Maybe that is why we say mediation process is a process which can be handled not necessarily by a legal professional person only. It requires a lot of intelligence and as Ashok was telling, the ability to understand human behavior and do counseling, basically enable each person to think and come to a conclusion that litigation is not the way which is beneficial for him. What is going on is much better, and he should feel that mediation is for his benefit. Maybe he requires a pre-mediation counseling perhaps to perhaps help him understand the benefit. What do you say, Ashok?
Sir, you're correct, especially in mediation. Whatever proceedings happens in mediation procedure, a private session or a joint session, all those details cannot be entered in the final, the settlement deed, settlement agreement. And only points 1, 2, 3, 4, 5. These are the points. He has to give this much amount to him, and he agreed for that. So whatever discussed 1 month or 3 months, whatever we have discussed, that is confidential. No documents can be maintained on that. Once the case is settled, all the documents, if they have maintained, they have to destroy. And no court can ask that mediator what you have discussed last 3 months. No, that privilege or that immunity is for the mediator. And no court can call the mediator as a witness to any case. If case is not settled and other party may use that some information in the court, and the court cannot call the mediator as a witness. And at the beginning itself, as a mediation procedure, both parties have to agree that whatever happens in the mediation proceedings, it is a confidential. So that's why it will take a little more time, but future is ADR.
Yeah.
Ashokji.
Yeah, please.
This Alipu from Mumbai.
Yeah.
A couple who in the process of contemplating to have a divorce, can they go to this mediation platform?
Sir, it is a very, very excellent method, and 90% of the settled mediation cases are matrimonial cases.
Okay. So
and they should appoint, or if they know somebody or known to them, they can hire the private mediator, or through court, if already case is pending, through court also they can request for the mediator.
Okay. The outcome of this mediation, is it legally binding, legally recognized?
Yeah. See, if case is pending before the court and you requested for the mediation, or court referred for the mediation,
Okay.
and case is settled in mediation,
Hmm.
and that mediation settlement document comes back to the court,
Okay.
and court puts its seal.
Okay.
Once the court puts its seal, it's a decree,
Okay.
and no appeal against that.
Okay.
Once any case settled through mediation, no appeal.
Okay.
See, the settlement is actually a mutual agreement which they sign. So it means that they have agreed. Okay, so if it is successful mediation, it results in a settlement which is signed, and therefore it becomes a self-accepted decision.
No, sir, in the normal course, if any case is decided in the lower courts, there is a procedure to go to higher courts, like High Court
Yeah.
and Supreme Court.
See, that is the benefit of mediation. If you file a case in trial court, then district court, then high court, Supreme Court, there is no end. Throughout life we have to spend there.
Yeah.
Once it is settled through mediation, because both parties voluntarily involved, with their consent they have signed, hence no appeal, unless if it is done through fraud, if you prove that.
Okay. So there one more query from me. A case is being with the commissioner. What is it? Cooperative commissioner. Cooperative commissioner in Maharashtra, we have a cooperative act. There is a cooperative commissioner is there who has to give a decision about the cooperative society working or the housing society working part. If there is a case in that court, can that also can be moved to this platform?
See, again, it depends on under which legislation you have filed a case.
Society Act.
Yeah, if what it is talking on mediation, is there any express provision on mediation? What it says, for example, under Commercial Courts Act, Section 12A says that unless you exhaust mediation, you cannot, your case is not admitted.
Okay.
So 100% you should go to mediation. Under the Consumer Protection Act, you have to request, both parties have to request for the mediation.
Okay.
If one party is not ready, then it cannot be referred for the mediation.
Okay.
So both parties' consent is needed. So depending on which legislation, assume that no provision is there in the given under which act you have filed. But if both parties are ready to settle the matter through mediation, then Section 89 is applicable. So judge will freely, happily he should allow for the mediation. So Section 89 is applicable to all types of civil cases.
This is a civil case. It's in the Commissioner's Court, and it is going for last 6 years. No postpone, so many reasons.
Yeah, it's the best way if both parties are ready to settle the matter, give and take, compromise, and if both parties are ready, then let us take a chance. It's not mean that you have chosen mediation, it should be settled through mediation. Maybe some extent 50% may be settled, 50% may not be settled. At least you are happy with the 50%.
Okay, thank you.
Thank you.
Yeah, Kodan Raman, any thoughts?
Sir,
I have no question except my observations. I can say this was there, the Indian old system, which we have forgotten. And because we lost the values, because we lost the ethics and morality, we are thinking of written laws. This is a new disease which has come to us. Now we are trying to get back to a kind of a new solution which was available with us, but unfortunate it is. In fact, I have seen in my childhood days, the disputes in a village will never go to any police station. Forget about going to a court. It was settled so amicably, and there was such a kind of a harmony between the people who are staying there. each one was living for the other. In fact, if it is not out of this one, even when there is a calamity like kind of a drought, people were ready to share whatever grains they had grown. That kind of ethical aspects were there. They said, don't leave my village. You are there in my village. Whatever you want, I will give. That kind of bonding was there. That we missed. We did not take that value up. And now we go everything in written things. We think everything ethics and morals can be deduced in writing and we can defend it. And this kind of thing, which has resulted in a new calamity. And of course, urbanization, commercialization have added. And
Agreed.
this is the way out. For me, in spite of this tendency there in the courts, why courts are not proactively suggesting it?
No, they are suggesting, no. See, there is a law itself, it says that before they take up a civil case, they give a suggestion. Now people will go back and they will come back and say, we were not satisfied with the mediation, and it continues. So if the people are ready to compromise, at least now there is a provision that all civil cases, the first question the court asks is, did you try mediation? Otherwise, try now. I will give you a support through our mediators or something like that. But most of the time, those mediations where parties are not willing, it will not succeed because they will spend another one or two meetings they will have and come back and say that we were not able to settle. Okay, one last question. Dr. Leme says, who pays the mediation fees? Ashok?
See, especially it's the sharing under the Consumer Protection Act, both parties have to share. And again, under which legislation you have filed, depending on that, there is a fee structure. How much your claim is there on that. For example, before the Consumer Protection Act, the especially up to 5 lakh, no court fee. The one who files a case, if his claim is up to 5 lakh, he is not giving a court fee. So why he should think of us referring it to mediation? If it is referred, he has to pay 50% of the cost of mediator fees. So these are the some challenges with us. But for big amount claims, yes, that is there. And especially under Consumer Protection Act, it will be fixed by the Consumer Commission, depending on the nature of case and total claim. And on that basis, they are fixing, but not at there is a standard yardstick how the commercial courts rules have fixed. We have not yet made, but it will come in future, so that they should not be arbitrarily fixing the fees. But especially if it is in regular court, if a case is settled, you are getting back as the plaintiff, he will get back his court fee. That is a very, very important thing that can be, he can give as some extent, some portion of the mediator fees.
This is Durai here. In continuation to the discussion, I have one point. Will there be any situation wherein, right, we will not have any monetary cost or monetary value involved in a mediation, so that, right, we cannot claim any fees, because no, we are collecting mediatory fees based on the value, right, the cost. So will there be any situation wherein we will not have any monetary benefit or monetary value, still we will be collecting some fees? Say for in the case of divorce, sometimes, right, mutual divorce will be the final thing, and that case, right, we cannot go for any, or we cannot calculate any mediatory fees, right? Any thoughts on that?
Sir, if you both parties themselves are already settled, why you go for mediator? So just ask the court for Lok Adalat. So just a miscellaneous case you file, just Lok Adalat, 1 or 2 hearing, it will be settled, and comes back to the regular court, it will put seal, that will be a decree. So mediator is also not necessary, especially when both parties are ready. When both parties are no claim on each other, then what is the issue? But for divorce, even though both parties are ready, the divorce decree is important valid document for next marriage. So that's why, even though both have agreed, it has to, the court seal is needed. That's why Lok Adalat is the best method. 1 or 2 hearing, you can get the decree.
Okay.
Okay, sir. Thank you.
Yeah.
Thanks.
Then I can propose a vote of thanks.
Yes, sir. It is my privilege, sir. So thank you very much, sir. Ashok Patil, sir. Actually, no, being an IT guy, right? No, I am not at all aware of all these stuff. No, each and every slide, bro, I have questions. But when I have the questions reserved for question and answer session, it is cleared in the next slide. So like that, it is unfolded all the slides starting from why we need that, how to do that, what are all the qualifications, what are all the characteristics of a mediator, how the innovation and technologies are going to support the mediation, and how the laws and regulations in the countries and regions are supporting to have this mediation rolling out. So you have almost rolled out everything, so which clarified all the questions. Maybe know what I have, because no, I am not a judicial guy, right? Not familiar to these things. Thank you very much, sir. Thank you very much for PPPI